Okay, we're going to go over the Chapter 4 quiz for legal environment of business. Question number 1. Leo's Lawn Care launches a new ad campaign that is so effective that customers of its competitor Tracy's Tree Care voluntarily choose to change their services to Leo's. So if we look at the question, look at the words that matter, which you always do. There's a lot of puffery that's thrown into these statements sometimes. So we see that Leo's Lawn Care launches a new campaign and it's effective. And the customers choose to change their service. So there's nothing wrong here. There's no tort. No tort's the answer. Question number 2. Mike Tyson, who is much bigger and stronger than Tiny Tim, threatens to hit Tim before hitting and injuring him. So we want to listen to this part. Extremely important. So we know that assault is the threat of injury. And we know that battery is the actual touching actually doesn't have to be injury, but the actual touching of someone, the threat of injury for assault, and the actual touching of someone to be battery. So here we're listening. He threatens to hit Tim. We've got assault. We've got hitting him and injuring him, which is battery. So we don't have to read the rest of the question. Tim will most likely recover for assault and battery. Question number 3. Justin waits outside Tommy's parked car and hits Tommy with a lead pipe as Tommy gets out of his vehicle. When Tommy sues Justin for battery, Justin will be considered a tortfeasor. A tortfeasor, and also, it's a criminal act, but here it's a tort, and a tort is a civil wrong, and a tortfeasor is a person who commits a tort. Question number 4. Wrongfully taken personal property without the owner's permission is conversion. That's true, because when a person takes another person's tangible property, it's conversion. Now, one thing I want you to remember here, with a lot of tort cases, negligence is an issue. With conversion, the taking of the property has to be intentional. There has to be intent. Next question. Ben delivers notices throughout his neighborhood accusing his neighbor of being a convicted sex offender. The statement is defamatory if It's defamatory only if the statement is false. If it's true, he can do that. Truth is a defense to most things. So the only way that would be defamatory if the statement was false. Question number 6. False imprisonment occurs when a person restrains another intentionally and without justification. That's true. That's the exact definition of false imprisonment. Question number 7. Judy accuses Sydney, a broker with Wealth Strategies Financial Advising, of fraudulently inducing him to invest in dangerous investment corporations. So up until this point, we don't have anything that actually shows that there's been any fraudulent activity. So the next part, whose stock price declines in value. So we know that still nothing has happened. The price goes down in stock, and the guy's mad. The reliance that gives rise to liability for fraud. So fraud would occur if what? And the correct answer is misrepresentation of a fact knowing that it is false. Misrepresentation of a fact knowing that it is false. That's when fraud would occur. Question number 8. Mary is selling her motorcycle. She knows that the brakes do not work. And there's a big part I want you to listen to. She knows that the brakes do not work. When a potential buyer asks Mary if there are any problems with the motorcycle, she says there's not. The buyer purchases a motorcycle based on the assurance. There's nothing wrong with it. We know that Mary's probably going to be liable, or she is going to be liable for fraudulent misrepresentation because she said that there was nothing wrong with it when she knew that there was. Next question. Which of the following is not an intentional tort against persons? I don't like this question, so it's not going to be on the final, but the correct answer is conversion. Conversion is intentional tort against property, but it is also an intentional tort, so it's a little confusing. If you missed that question on the quiz, don't feel bad. Question number 10. Richard is an avid baseball fan and attends the baseball games whenever he can. Richard considers himself an expert on all things, including risks related to baseball. Typically, there's a lot of puffery in that, but there's going to be a lot to that. So he considers himself an expert. He knows about these things. He knows when he goes to a ball game, the risks that he's taking. So the next part, one day a ball flies into the stands and hits him, seriously injures him. Richard can probably successfully win a case against a sports stadium based on none of the choices because of his knowledge. So he's not based on negligence. There was no negligence, breach of duty of care, none. None, no defamation. So the correct answer is none of the choices based because of his knowledge. So the knowledge plays a big part of this question. Question number 11. An Arkansas state statute requires amusement parks to maintain equipment in specific condition for the protection of the customers. Manila's massive fun amusement park fails to maintain its equipment. Big part. That's we know that they failed to maintain the equipment. So we have that information. Then Zach, a customer, is injured. So we know that the amusement park is going to be negligent. They committed negligence because they didn't maintain their equipment as they were supposed to. The next question, the public disclosure of private facts about a person is an invasion of privacy. That's true. There's a little that you could discuss more with the information we have here. It's true, but if you're a public official or you put yourself in the public eye, like running for a political office, or you're a celebrity, things can be disclosed. You're not completely protected like you are if you're a private citizen. Next question. Joshua is done shopping and backs out of his parking space directly into Abe's vehicle. Abe may recover $7,500 to cover the cost of the repairs if Joshua failed to act as the correct answer is a reasonable person. You're going to hear a reasonable person a lot. You can almost get rid of all the other possible answers, not blameless or faultless or even realistic. So the only answer that even makes sense is a reasonable person. Question number 14. Jean is playing a video game on a defective disc. So that's a big part. There isn't a defective disc that melts in her game player, starting a fire that injures her hands. So her game player is torn up and she has physical injury. Jean files a suit against K-Tech Incorporated, the game's manufacturer. K-Tech is held liable under the doctrine of strict liability. A significant application of this doctrine is in the area of the correct answer is product liability. The elements that I want you to look at for product liability that are necessary, and you can apply it to this, is that the product actually caused harm, the product was defective, the defect in the product is what caused the harm, and then the product was being used as it was intended to be used. So if all of those things come into play, then there's typically a good product liability lawsuit. The last question, Erica trespasses on Big Box Store Incorporated property. Big Box's security guard uses reasonable force. That's the big element of this that you'll need to see or need to understand. As soon as you read that the security guard used reasonable force, we're going to know that probably that's going to be justified. So Big Box is liable for nothing. So if the security guard used reasonable force just until the police took over, until they arrived, there was no tort there and nothing done wrong. Okay, that's it for chapter 4. We'll do chapter 5 today or tomorrow. Thank you.